Good morning, everyone, and thank you for joining us this morning for our third installment of our data security series. My name is JP Harris, and I want to thank you all for shaking off the cobwebs this morning after a couple of late nights of watching a lot of cable news. I wanted a couple of housekeeping matters before we get started. We will take questions and try to answer as many of them as possible today. So if you have questions, just use the Q&A function through Zoom. And we will be recording this webinar. Today's our third session, and it's no problem if you've missed either of the first two sessions. These each are sort of discrete topics, but you can always go back to our website and view the videos. This week we're going to be talking about privacy policies and compliance in sort of a post-COVID world. Next week we're going to be talking about vetting your vendors. As we all share our data with more third parties and are somewhat responsible for them under the regulatory frameworks that are being imposed on all of us. We're going to talk about how to sort of measure up the people you're sharing your data with and making sure they're compliant. And on December 3rd, we're going to focus in specifically on what the hackers are doing and give some tips about how to protect yourself in that regard. So some brief introductions. My name is JP Harris. I'm co-chair of the Data Privacy and Security Group here at the firm. I'm a litigator. Within our data privacy group, I generally am the one that counsels clients through data incidents or breaches. I've also been counseling companies on record retention and data management for a long time, which sort of dovetails into what we're going to be talking about today. My partner, Doug Verge, is the co-chair of the group, and he principally drafts the policies we're going to talk about today and the procedures, and works through some additional regulatory compliance issues. So we sort of tag team. We're going to talk today about how Doug and I work together, and we often bring in information security professionals to help with risk assessments that we're going to talk about today. And to help us with that is my colleague, Tom Mitchell. So I'm going to pause here and let Tom give you a sense of his background, and then we'll get into it.
Howdy, folks. Tom Mitchell. I've been in the IT security realm for probably 20 years, give or take. I'm a certified information system security professional, CISSP, and it has allowed me through a few different jobs to guide clients and guide the companies that I work for to make sure that they're doing the things they should be doing as far as IT security is concerned, because it's more than just, usernames and passwords. Goes into a whole realm of other areas that most folks just forget about or don't realize are connected to IT security.
All right, thank you, Tom. So we're going to start, if I can pull off this technological marvel, with a little audience poll to get everybody working today. And hopefully you see that now. So the poll question is, has your company within the last 2 years conducted a data security risk assessment and updated its policies and procedures? So we'll give a couple of minutes for you all to respond. We've got a particularly compliant group today. You guys should be giving the webinar. I can just go back and have my cup of coffee. All right, these are the results from our little quick poll. So most folks on this call have done a risk assessment, so that's terrific. And hopefully we're back to the screen. So the question is really, why am I here, right? I was only a philosophy minor, so I won't try to answer this question. But really, the question really is, why are we so concerned about data privacy and security? And the answer really is that this is one of the most rapidly changing areas of the law, and it applies really to every business, all shapes and sizes. There are new statutes and regulations being passed and being considered. Those statutes create new avenues of liability and other exposure, both exposure to consumers and users, anyone about whom your business collects any data, but there's also a significant regulatory overlay now a new set of regulators in the space for all businesses, even those outside traditionally regulated industries. These are imposing some hygiene matters on all companies to protect against interruptions. And I think, if anything, the last 7 months have taught all of us what it is to have your business interrupted on one level or another. So we've gotten a taste of it under circumstances where we all still exercise some measure of control, right? We still could get to our data, and it was just a question of setting up laptops and getting people remotely connected for most of us. But there's a whole different ball game when a hacker is taking control of your data, or your data has been exfiltrated, and you don't really have control. But we've gotten a taste of that. Customer confidence and brand reputation has always been a significant component of the risk in this area. If you can think about the major retailers who have had significant events, and customers have shied away and moved to competitors. So that's always been a risk hanging over everyone's head. And there's also an employee relations component to it. I mean, every company possesses some personal information about its employees. And when that data is exposed, it's often a difficult conversation. So why is this more of an issue post-COVID-19? Well, the business environment has changed, and we may not go back to the way that it was before, even after the pandemic is resolved and we're all standing in lines to get vaccinated. Those press reports are that a lot of employers are realizing that maybe they don't need so much lease space. We don't have to have employees all congregated together, and employees are getting used to being able to work from home. They're going to advocate for themselves to be able to do so. So we might not go back to the brick and mortar environment that we were in, at least not to the same degree. So that just means more transfer of electronic data to a bunch of new access points. And you could be, as we're going to talk about, you could be processing data in states you weren't previously, just because you've got now a remote employee that sits in California or Virginia or wherever. You're going to be doing business with consumers, and as you go more online and less dependent on brick and mortar, you'll be doing more online business. So that just means more data, more interfacing with more states and countries, and therefore coming into the purview of those various laws. All right, a little bit more on the legal landscape. We've had industry-specific privacy laws for certain industries for some time now, right? The healthcare space has had HIPAA. We've had these other, if you were in any of those spaces, you've already been forced to comply, but the world's changing a bit now in that we don't have a federal general privacy law, and the states have stepped into that arena to some degree already with breach notification statutes that carry some regulatory risk of their own. But states are now also contemplating getting into the privacy regulation business, and California was the first notable. But New Hampshire considered a bill last session that was very similar to the California statute, and Massachusetts has done similar. So the states are going to start, it is very likely that states will start to impose more general data privacy regulations on you, regardless of where you are. And there, just a reference here to GDPR, if any of you are doing business or collecting data on folks that reside in or that are present at the time in Europe, you've undoubtedly come across the GDPR, which has been kind of the model for California, and therefore will be somewhat of a watered down model, perhaps for other states. There are new contractual obligations too, as you start to sign up vendors or interface with third parties who are themselves either regulated by California or GDPR. They have requirements now that they are passing down to you. And there's an effort to shift risk and to impose specific protection regulations by contract through all of the people that are sort of interconnected in the data sharing world. All right, there are some other risks to talk about, and that is The FTC in particular has cracked down on companies that misrepresent the extent to which they protect data. So if you have a policy that we're going to talk about at the end, and you post it on your website or you advertise it to the world, but then you actually don't follow through on any of that, in addition to the regulatory problems for not complying, FTC can sort of tack on and tag on some additional fines for misrepresenting. The attorneys general, like for example in California, are being empowered to enforce these privacy statutes. So there's another sort of watchdog out there. We're going to spend time at the end today talking about consumers' rights that are being granted to them under the statutes. You have to figure out a way to give them those rights. And then the contractual clauses we talked about before may lead to some business-to-business disputes and sort of risk allocation. So how do you actually trigger one of these data privacy laws? Well, it doesn't take much. There's really sort of two components. You need to process personal information. Personal information is very, very broad. It's really any kind of information that can identify a person. Name, address, social security number, etc. One of the more difficult ones to deal with is IP addresses, because in the world we live in, we're frequently trying to collect information about people that view websites, to be able to market to them, to learn what they're interested in. And the fact that IP addresses are on this list means that if you're doing e-commerce really of any type, or Google Analytics, anything like that, you need to be mindful of privacy laws. Processing. So we've talked about personal information is really anything that identifies. Processing is really doing anything with that personal information, even destroying it. So again, if you're engaged in e-commerce, this should be on your radar screen. Now, these privacy laws, GDPR and the California statute in particular, and we think those will spread across the country to one degree or another, require processors of personal data to have a lawful purpose. And there's a couple of, and figuring out what your lawful purpose is not necessarily as straightforward as you might think. But the top line is getting consent from the data subject, right? I'm giving you permission to use my data. Or if you don't do that, there's a sort of a menu of legitimate purposes, and you have to be transparent about what those are. You have to tell the world, what is my purpose? Why am I collecting personal data in the first place? You can't just collect personal data on a whim. You've got to have a legitimate purpose. But the key for this slide really is, once you've identified whatever that purpose is, you cannot exceed that purpose without running afoul of the statute. One little note here: even if you're relying on consent, you have to be ready for the possibility that the data subject is going to withdraw consent, right? I previously allowed you to collect this information on me, but now I've changed my mind, and we're going to talk about the sort of problems with actually implementing those rights. The regulations at their core are designed to give consumers rights, but also to ensure some level of security. And so these statutes frequently require that if you're going to collect personal data, you need to take appropriate steps to protect it. And there are really three categories: organizational, administrative, physical, and technical. The physical is really your space, right? Your physical confines of your space, who comes and goes, who has access to the servers, etc. But as we move into a remote workforce, you now have more people who are accessing from outside your sort of traditional four corners of your business. So your physical safeguards need to extend into people's homes and into their home offices if that's where they're accessing your data. The technical measures are more Tom's world, right? The information security folks and your IT folks work together to make sure you're as protected as you can be. These regulations and statutes also manifest the intention that you can't, once you collect the data, you can really only keep it for as long as it matches up with your legitimate purpose. The days of collecting personal data and just keeping it forever, for marketing purposes, those are going away. The marketing folks really hate this part of it. If you're going to collect personal data, you need to state sort of explicitly what it is you're collecting and how long you're going to keep it. It used to be that your record retention plan was sort of an internal plan that you just implemented inside, and nobody really from the outside got to see that, but those days are changing. It's also sort of a forced movement away from the pack rat syndrome that you are no longer really going to be allowed to keep personal data forever. There's going to be this impetus to delete it. And from a risk management perspective, that's actually probably a good thing. But again, the marketing folks hate this kind of stuff. There is a possibility that you could comply with these laws by redacting out some of the personal information, right? If you collect something that is, useful to folks, useful to parts of your business, but you can strip out the personal parts of it and keep sort of the business parts that you might need. So this slide is really, so when a client comes to us and says, I want to comply, I want to become compliant with this new data privacy world, what do I have to do? And these are sort of the initial questions. There's sort of a foundation or a self-assessment that needs to be done so that you can sort of get off the ground and figure out what it is to be done next. And the first question is, which laws apply? That's not as straightforward in this day, in this present environment. It's not as straightforward a question as you might think. Trying to figure out whether you actually collect any data on people in Europe, you'd be sort of surprised if you're collecting if you're placing cookies and collecting IP information on folks visiting your website from Europe. You need to analyze that question. Do you do sufficient business in California? Are you a not-for-profit, in which case you're exempt from California, right? These are all kind of the questions you got to go through. The next one is crucial, really, and it's the part that we really cannot skip, and that is, what kinds of data do you collect and where is it? This is what's otherwise known as data mapping. We need to help our clients get through that process so we know what we're trying to protect. And this feeds into the policies and procedures because you need to disclose to the world what it is you're collecting and what you're doing with it. The third one is very important, and it's, how compliant do you want to be? If you're a small employer in New Hampshire and you don't do business in California, or you do only limited business in California, the risk of enforcement from California might be small, or it might be even more attenuated under GDPR purposes. So we don't just give a one-size-fits-all package to clients. They're individually tailored, and it's a questions of risk tolerance to some degree. But over time, as these privacy laws become more prevalent, you won't really have much of a choice. But we do stop and focus. How compliant do you want to be? And what do you have in place already? Can we build off of some policies and procedures that you already have in place? So risk assessments are a key part of this process, and it's really the blending of your team, your operational team, the legal team, and information security folks like Tom. You need to bring these sort of three legs of the stool together to do this properly. And the question is, can we identify internal and external risks to your security, and do this in a methodical way to identify where the vulnerabilities are from the, remember the three sort of categories we talked about: operational, physical, and technological. Can we identify those safeguard weak points, and what can we do to plug them up and come up with a plan? So I'm going to pause here and bring in Tom, because this is really more Tom's world as an information security professional. He's going to talk to you for a few minutes about what it is an information security person will do when they come into your shop for purposes of this risk assessment.
All right, so if you're going to have a risk assessment conducted, the first thing that I would always ask for is what sort of logging do you have within your system? And I'm looking for logs from every single piece of equipment that plugs into the network. It's important to have that. If you're not capturing that information, you need to set a plan and begin to do so. Have you done a vulnerability scanning and assessment? Because there are, for every device you have plugged into your network, there's a whole series of vulnerabilities and things that need to be done. Regular, consistent, and documented patching goes in hand in hand with the vulnerability scanning and assessment. If you're not patching your systems and your servers and your switches and your cameras and your door fobs and everything else that plugs into the network, don't forget your printers and your copiers. You need to be doing that, and you need to be documenting that you're doing it. It helps in the risk rating for your business technology. So can we conduct business if we don't have X? If you suddenly have a vulnerability within your copier scanners and you have to turn them all off and wait for the vendor to come in and update them, can you actually do business without them? Some places can, some places cannot. Personnel risk. Do you have succession planning in place? If 3 people leave the firm or office today, how are you going to get the jobs done that need to happen that they took care of for you? And be sure that you're doing cross-training of critical roles. Is there more than one person in your office that can do payroll or bill payment or wire money? Those are 3 things that are generally overlooked or not paid attention to until somebody is out of pocket at the wrong time. Backups, and more backups. Goes all the way back to the beginning. Logs from everything inside your network and backups are the 2 critical pieces that folks are looking for as part of a risk assessment. Next slide. Policies and procedures. Part of any risk assessment is looking again at policies and procedures to make sure, A, that you have a policy for it, and B, that you're actually doing it. So it's adherence. It's not just having them. Once you have them, you have to adhere to them. Do you have an incident response plan? Again, if there's a problem within the network, regardless of what it is, do you have a plan to deal with it so that you can at least start addressing whatever the situation may be? Again, business continuity. Everyone should have a business continuity plan, because it's more than just we don't have any servers. It's we don't have a building, we don't have electricity, we don't have internet, we don't have water. Business continuity is a large plan. It's more than just IT. And then disaster recovery. We've lost our building. We don't have anything to go back to. Now, how are we going to recover from that? And what things do we need to recover, and in what order? All pieces of that, this slide and the last slide, go together as part of your risk assessments.
Great, thank you, Tom. So when Tom and the operational staff are sort of done with that assessment, it comes back usually to the lawyers to try to help document and create the policies and procedures. And policies are the easier part, I guess I would say, from the lawyer's perspective. It's putting the words down on paper that advise the data subjects about what data you possess, why you have it, what you're doing with it, advising them of the rights. But the procedures part of it is the more creative, and it's the harder, but and more challenging, but maybe the funner part, at least for the lawyers. How are you actually going to manifest these policies on the ground with your workforce? How are you going to train your folks? How are you actually going to implement the consumers' rights that we'll talk about in a minute? But it's not just enough anymore to just throw the policies up on the website and tell the world this is what you do. The complete sort of plan and the complete compliance is actually figuring out a way to implement them. So there's a whole long list of data subjects' rights. These come mostly from GDPR and CCPA, the California statute. But this gives you a sense of what your consumers are all going to now be trained to know, that they should expect to have these rights. They have the right to know what information you collect and possess. So that's something you'll tell everyone with your policies. But they have the right to access their personal information. So how is it that if I sent you a request tomorrow that I want to know all of the personal data you've collected on me, how is it you're going to respond to that request? They have the right to correct errors, right? If there's something wrong about the information you've collected on me, I have the right to correct it. You have the right to be forgotten, right? This is the one that caught a lot of attention when the GDPR was first passed, but it can be extremely difficult to implement, particularly, I think Tom will tell you, from a backup perspective, right? Our backup systems are not designed to excise out the one line that relates to me out of all the stuff that's being backed up. deleting my record from their active data is sort of one thing, but getting it off the backups is a whole nother animal. Some other rights that consumers now have is the right to restrict how you process personal information. So let's say after your data mapping, you've identified these are the 6 or 7 things we want to do with the personal data. Well, I get to choose as a user of your services. I also have the right to get my data or get it transferred to another vendor. So you can't hold people hostage or make them start over. You have to figure out a way to interface with a new vendor, or at least give it back to the consumer in a way that they can transport it. And they have the right to object. They have the right to opt out to certain processing. So when your privacy policy says these are the 5 or 6 things we're going to do with your personal data, consumers get to pick and choose from that menu. And again, implementing on the ground with your operational folks what it means if we want to do all these certain things, but I got a particular consumer that says no. How are we going to actually do that? And you have to document not only the policies, but all of these events, right? If I contact you and say, I want you to delete my data, there has to be some record of that so that you can show from a regulatory perspective that you've complied. They have the right to sort of opt out of automated individual decision-making, right? We've created this web environment now where some folks are being screened based on certain criteria, and they have the right to opt out of that. And they have the right not to be discriminated against. If I opt out of your cookie policy, you can't prevent me from accessing your website. We've all seen those banners, normally across the bottom of a website that sort of eat up most of the page. Well, if I don't accept your cookie policy, I still get to use your services. You can't lock me out. So I hope we've given you some sense of where the law is moving in this regard. And even for those of you who are not directly subject to GDPR or California, there are some things you can start doing now and laying some sort of hygiene groundwork to get yourself ready. And again, if you're going to be interfacing with consumers in other states, or you have employees now in new states, you need to sort of reanalyze your risk profile. I also hope we've given you a good summary of what risk assessments are like and their utility for you. Again, choosing the right balance of compliance based on your risk, but identifying gaps, coming up with a long-term plan. It's not like the risk assessments can identify a whole host of problems, but the good plans put you on a path to correct them over a period of time. You identify low-hanging fruit or the most important vulnerabilities, and you clean those up as quickly as possible. So I hope that this has been a good intro to that topic. I'm going to go now to the Q&A, and I don't see any open questions. You should feel free to reach out to me or to Tom if you have specific questions or you want to follow up. The slides will be available for download too, I believe. So I'm just going to hang in here one more minute in case somebody has a last minute question. But
one thing to add there, JP, is,
yep.
If you have the right to be forgotten and you tie that right to be forgotten properly into your record retention, then you can also integrate that into your backup retention plan, and they all 3 go together.
Oh, good. Yep. Well, that's the kind of riddle that we have to solve for folks, and
right.
they're in different spots depending on how they do their business. But well, we've come right to 9:30. I want to thank you again for participating. We hope to see you next week at our 4th installment, and please feel free to reach out to me or to Tom if you have any questions.